Possibility of considering the vacant property board. The vacant property review board's been around since the late 70s. The ability to create them. The only entity in Lebanon County that's ever done it is the city. The city's had one since early 80s probably. The last mayor to use it extensively was Mayor Onspot. We had several properties go through the process in the city, were declared blighted, and that action alone was enough to get them renovated. Either the existing owners renovated them or they found buyers who were willing to renovate them within 6 months. So we never had to use eminent domain and buy the properties. They were all renovated and we were able to move on. That's a happy ending. I think the experience of other counties that have it, a good many of the properties, that's what happened, but occasionally you do wind up having to buy property. Over the last 7 or 8 years, the legislature has been moving a series of bills that came to be known as the Blight Package. Originally part of that, but probably the first of those things were changes to the eminent domain code back in 2006, which were a reaction to the Supreme Court Kelo New London decision. You may remember that one. It was a big flap that people suddenly discovered that you could buy properties for private purposes. And the Supreme Court reaffirmed the ability to do that, and many of the states looked at their urban redevelopment laws and eminent domain codes and made changes to them to tighten the process for that, as did Pennsylvania. So probably the first thing that in that quote blight package that moved was the 2006 changes to the eminent domain code. That the one sheet I gave you today that you hadn't seen before is a part of that package. And then there was a whole series of bills aimed at giving local government more tools to use for deteriorated properties. A lot of them related to code enforcement. There's a Conservatorship Act which allows municipalities or redevelopment authorities or even individuals in some cases to petition the court on a vacant property that essentially is abandoned to assume conservatorship. A lot of times what will happen, a bank will issue a foreclosure notice, and this is particularly in cities, on a property, and then the owner of record vacates the property. But the bank, rather than to be held responsible to maintain the property, never files the foreclosure paperwork, so title never moves to the bank. And yet this property that's in limbo, the owner of record believes it's not theirs anymore, that they've been foreclosed upon and have vacated, often are out of the area. They become nuisances in the neighborhood, yet there's really no way to force the bank to make corrections. The Conservatorship Act permits communities to petition the court, they name conservator for the building. You have to give the owner of record, and if there's any debt against the property, the lien holders have to be given due notice and have to be given an opportunity to correct the deficiencies. But if that time period moves, the court of common pleas can grant conservatorship to a municipality or redevelopment authority, or in some cases an individual. And then that receiver or conservator can make the repairs, and the court may actually grant super lien position. So that, let's say the property is totally liened already, and usually they are at that stage because they've been foreclosed upon, so that the value of the liens is much higher than the value of the property. Well, the court can say, bank, you didn't within your time frame agree to make repairs to this property. This conservator can borrow X dollars to make these repairs and can sell the property, and if there's anything left, you get it against your liens. If there isn't, the balance of your lien is wiped out. The city has done that on a modified basis, never to buy the property, but to at least take conservatorship and sell property. They did one of those earlier this year, over in Brandywine Street. Sold at public sale, and repairs made by the buyer, or being made by the buyer. The biggest county user that I think so far has been Butler County. They've done a flock of them out there for some reason. That law is in place. You don't have to do anything about that, but that was probably the biggest piece of the blight package, is the Vacant Blighted Property Reinvestment Board. And what a board of that nature does, we would open for nominations to the municipalities and the county properties that they believe to be blighted, that they don't have a method through zoning to take any corrective action with. And Chris gets calls like that all the time. We do as well from communities looking for community development block grant money, but unless it's declared blighted, we can't do anything with community development block grant. Not a lot of calls. If I get 2 a year, it's probably a lot, and I think your experience is about the same.
That's pretty much what I get, 1 or 2 a year.
But they are out there. If you would establish such a board, they would not consider a property unless the community in which it resides nominates it to you. You know, we wouldn't be going out looking for someplace in South Londonderry. If South Londonderry came to us and said, we have this property in Campbelltown that we've got issues with, we can't get corrective action through zoning, there would be a fee they would pay to go through the reinvestment board process. The board would give notice to the property owner, go through the process described. And Cumberland's handout on how their process works is a pretty good, simple one, and you have that. And I won't repeat that to you, but their analysis of how theirs works is pretty much the way one here would work as well. So you ultimately get to the point where the reinvestment board would find the property to be blighted. Because of the changes in the eminent domain code, the Redevelopment Authority would also have to make a finding of blight against the sheet I gave you today. At least one of the components that's on that list would have to be satisfied in addition to the certification done by the reinvestment board. At that point, again, notice would go to the owners. They could choose to make the repairs themselves. They could choose to find a buyer who is willing to make them, or if they're unwilling to make the repairs, and we have funding in place, we could actually use eminent domain powers to acquire the property in any one of a number of varying forms. Depending on the nature of the property, you might only do a partial taking of the structure and leave the land with the owner and lien the land for at least the demolition costs. You might do a total take if the land is land that the municipality would like to hold for some reason. Maybe it's in proximity to other land the community has that they could use as a community resource, or maybe it's in an area that is in need of parking that they could utilize for parking. You could do a total take if it's in an area that is undergoing other development. You know, if it's a big enough lot that's buildable, you would probably do a total take and then resell the vacant land for development, for other housing. That's a case-by-case decision that gets made after you have the nominated sites, but there are various options as to how you would acquire property, how the Redevelopment Authority would acquire property. How do you pay for it? Well, the blight review process is paid for by the community, and the fees that are in Cumberland's ordinance are way too low. They've told me they're in the process of redoing theirs, and Chris can speak to that just from their experience with zoning.
Yep. Yeah, I think it says $350 is the fee in Cumberland County, and that wouldn't even cover the advertising that's required to be done. So we'd have to look at probably $500 or $600 at a minimum.
You'd want to cover your costs, but the community is at least paying what it's costing you to get through the process. We have two locally generated sources. One, if it's a residential reuse, we could use the Housing Trust Fund, and we could allocate a small portion of your community development block grant. As it happens, DCED, as I meeting 2 weeks ago, is most probably next year going to add blight removal as an eligible activity for their competitive CDBG program. And I think if we had this model in place, particularly with some local funding, we'd have a good opportunity of getting a competitive CDBG grant to match whatever money we would put in. Their competitive money has always been oversubscribed, but because of all the money that came out of H2O and Penvest the last couple of years, they actually have 2 years worth of funding sitting up there that they have applications for. They typically do water and sewer projects, and everybody got fairly decent grant money out of Penvest over the last 2 years and out of H2O. And applications that would have gone nowhere a few years ago might get funded up there this year because just nobody's applying for water and sewer. The need seems to have been satisfied by Penvest and H2O. So I think we have a really good shot if we have this in place of getting matching CDBG competitive money in addition to the grants that the county already. Or if you would choose to go with this, we would have to rework Cumberland, as you saw, has two ordinances. They have an old one and they revised it a few years ago, but they haven't revised it since the 2006 and the domain changes. So we'd have to rework their ordinance, exclude the city, which has their own board already, make the changes on fees, any other changes that we would get input from you folks on. For instance, the composition of the board in Cumberland, I believe it's the chairman of the Redevelopment Authority or their designee, the chairman of the county commissioners, the director of the planning department, and 4 members of the public. I don't know whether the chairman of the commissioners would actually want to sit on that board, or if you want that to read as or designee as well. I think that it's important that the director of the planning department is in. So that's the kind of tweaking we'd have to do to the ordinance, and of course the solicitor then would have to review that. Chris and I would work up a draft ordinance that we would be comfortable with. We would get it to him for review, and then ultimately would have to be advertised. To the ordinance, of course, has to be advertised for adoption. So in a nutshell, we believe strongly that that is a tool that Lebanon County or municipalities need, and that that's one that you should strongly consider implementing. So maybe we deal with that before we get into the other stuff.
Yes.
Any downsides that you could see to us?
Well, I'm not answering no to that question. Today's kind of my first glance at it. Ray and I spoke briefly about it last week, and I got some of this information as well, but this is almost as informative for me as well. So I'm just kind of getting up to speed on it.
Yes, I have numerous questions about this ordinance. I don't stand in line to support eminent domain. I look at the Armour Bordner situation, and taking people's property is not something I take lightly. Number one. Number two, how many municipalities are knocking down our door to execute this ordinance?
Well, as I say,
It should be an easy answer.
we almost
with
have to
numbers.
do it by implication. We get calls, probably 2 a year, for requests for assistance on properties that communities, vacant properties that they have serious blight issues with. What can you do to help me? Right now, my answer is nothing.
And mine
That's
is as
Chris's
well.
answer right now.
But my point is, they have a remedy. They can implement their own. Is that not correct? The city has done this.
You could, and
Why
I
would
would
we
advise
take?
against it.
Why would we take away powers that is in the hands of the municipalities?
I would advise against individual communities because they would use it so seldom. Berks went that route. Berks did. They have individual ordinances by community. Of course, the communities, the county's larger and the communities are larger, and the ones that adopted it tend to be the bigger communities. To do it here, you have a property that you need to deal with. You don't have an ordinance in place. And the communities are not going to adopt the ordinance until they see the need. You would never match up on time frames of what you need. In a county our size, I personally think, and with communities our size, the Cumberland approach, where there's a county ordinance in place and the community only uses it if they want to. That has to be the number one premise here, to be right in the ordinance. The county will not consider any property that is not nominated by the host community, where the property exists. The issue when you have a plethora of review boards would be an issue of training, because they might go 3-4 years before they see a property. They'd have no idea as to process. It'd be a constant re-education process with them of why they're there. It'd be constant loss of members. They pass the ordinance this year, they wouldn't use it for 3 years, somebody moves out of town, dies. The community boards would become stagnant. With the county board, I'm confident you would have 1 or 2 properties a year that you would deal with, maybe a few more in the first year, because any backed up demand would probably come in the first year. So if it's going to be done at all, I would recommend it be done at the county level. Cities are fine, they're large enough, there's enough properties of concern there for it to work in the city. In a township or a borough, that you'll never have enough properties to justify establishing a board in my mind.
I hear you, Ray, but my point is, if we are going to declare anything in the county burning, open burning, we say, okay, we're going to stop it. We don't just do it. We poll the fire chiefs. Have we polled the municipalities? Have they come back 80% and said, yes, they would like us to do this for them? Have we communicated with them at all?
I met with the township managers December. Now granted, there were only 5 communities there. Now they were the 5 largest communities. They were all supportive and all indicated that they would likely have properties at some point to nominate. But that's only 5 communities. That's the only ones that the managers meet
26.
formally at lunch quarterly, and you never know who's going to come, who's not going to come. And that's who we met with.
Well, I'd like to see a poll, number one.
But why? If they're going to nominate properties, what would it matter? If Community A has no interest in it, they would never nominate. But we know from the calls we get that there's enough demand out there that there would be use of it. You can certainly poll if you chose to, but what would you do if 3/4 of the communities were supportive, the 1/4 that weren't, you would exclude them from the ordinance also? And then elected officials change in 2 years and decide they want to use it and find out they're excluded? I'm not linking
Okay,
that.
I've given my first request, and you can take it or leave it, but I've given my request. Number
Yeah.
2, what do we do if that property has environmental problems? Is there an environmental assessment done? Does the county take ownership? Is that putting us at liability? I think that that's something I need an answer to. Number 3, what about historic sites? I mean, there are some, I can just remember the Coleman mansions disappearing in Coleman Park. Yes, the city took them down, but there may be other buildings out there significant to this community, and we're going to just tear them down. I mean, I read this, I
Yeah.
had so many
You're
questions.
exactly right. If we use CDBG funding, we will have to do an environmental review and also a consultation with the state historic officer.
And my final question, how many of these are local people? Or are they absentee landlords? Or what about, it says, 2 years, 6 months, whatever. What if somebody's away in the military, serving their country, and their taxes don't get paid because of, I don't know, the wife has a nervous breakdown, whatever the case may be. They come home and their property's gone. I mean, there's just so many questions I have about this whole thing, and I'm sharing them with you because I personally am not ready to vote on this today. I need more answers.
Well, of course, taxes are not an issue here, but it would not be because of not paying taxes. It would be because of not improving the property. or
Well, it
not
says
keeping
in
the property
here,
up to standards.
I read it somewhere, something about taxes in arrears by 2 years.
Well, that's for a blight declaration, but the property still has to be blighted under the redevelopment law, which the certification board is making. That's what the redevelopment authority finding. You're giving notice to all the parties. The requests I've seen in the past, it's about 50-50 between absentee owners and local owners. There'd been a fire in the old lawn mill, and it just sat there. They had no insurance on it. And they came to the county, and the commissioners at the time actually came up with money to demolish that for them. We had to do, we got community development block grant money for it. We had to do a historic review on the property. The fire had been so extensive that the state historic officer signed off on it because there was nothing left of the historic nature of the building at that point. That was a local owner, but because they had no insurance, they had just left it sit right in the middle of lawn. And the township came to the county, and the commissioners at the time assisted them with block grant money. I've had both owners and investors, so you don't know what you're going to get. It could, my experience in the past, I would have said 50-50, but I don't know that because you don't know what will be nominated.
I can just see us setting us up for a scenario where somebody has a really badly polluted property and it's astronomical to clean up, they walk away from it, and we end up taking that on.
Well,
we don't need that.
You probably would not take on that property. When you did your environmental review, if you have a concern like that, you'd never institute eminent domain. Why would you buy that kind of a problem?
I think Commissioner Litz has raised some legitimate concerns, and since our solicitor is here, like he said, it's a learning process for him. It is for all of us, so I would like Dave to take a look at it and, give us some advice as to the direction we should go with this.